Hello, and welcome to another edition of Coffee Talk with immigration attorney Brian D. Lerner. In this particular video, I'd like to discuss the basics of family law immigration. Now, there's lots of different ways of coming into the United States. Some is family, some is employment, some is religious, asylum, persecution, uh, through winning deportation, all kinds of ways. But one of the most popular ways, of course, is the family-based immigration. But I had a client come in the other day and she said, "How long does it take to come in on a family visa?" And I said, "It depends." She goes, "Well, I thought it was just one type of petition, and whenever it's approved, we can come in." So I thought that it would be a good idea just to give you a basic idea of what family immigration is about, so that you know where you stand and you know if there might be some other options that you would like to take. So first of all, with family immigration, there's pretty much five different categories, okay? And the first category, which is the category you want to be in, it's the most preferable category, is called the IR category, or immediate relative. And what that means is that if you fall under an immediate relative category, that means there's no visa waiting. You don't have to wait for a visa number to become current before you can immigrate to the United States. And believe me, when I start going into, how long people have to wait in order for the visa number to become current, you'll do anything you can to try to be under an immediate relative category. So talking of a media relative category, what three situations exist where you fall under this immediate relative category where the U.S. laws have said that these relationships are so important that there's no limit on the amount that can apply and there's no visa waiting? Well, first is a spouse to a U.S. citizen. Okay, so if you marry a U.S. citizen, then you will be under an immediate relative category. And of course, we're not going in here about the bona fides of the marriage or marriage fraud or anything in regards to that. We're going just the qualifications for an immediate relative category. So keep in mind with this particular one, if you marry a lawful permanent resident and then that person later becomes a citizen, boom, you're under immediate relative category. Okay, the next is a U.S. citizen petitioning a child under 21 who's single. So if the child is again single and under 21, falls under immediate relative category and can be petitioned right away. And again, the only thing you wait for is processing time. So, if it takes 6 months to a year to process everything, that's not visa waiting. That's just, because there's 10,000 other applications the officers have in front of you. And then the third one is a U.S. citizen over 21 petitioning a mother or father. So that's it. Those are the three types of immediate relative petitions. Okay, now the next categories are what are called preference petitions. And these are petitions whereby it is necessary to wait for a visa number to become current. And then once it becomes current, then you can go forward and process. Now, I have a lot of people who come in and they say, well, I filed the I-130 and 6 months later it was approved. Why isn't my, beneficiary here in the United States? Well, keep in mind that having, and the I-130 is the initial petition to go forward with this. Now, keep in mind that having an I-130 filed and approved does not mean that the visa number is current. Let me give an example. Let's say that, U.S. citizen petitions his brother and does this in 2003, whatever, and 6 months later it's approved. It means that the I-130 has sufficiently shown that the petitioner is a U.S. citizen, has shown the familial relationship between the petitioner and the beneficiary, and has proven that the beneficiary is who the beneficiary claims to be. That's all really the I-130 does. Now let me tell you about the visa waiting. It's basically like waiting in a big line, okay? So you file the I-130 and you get in line. That essentially establishes what's called the priority date. So you get in line and you see way up, thousands of people in front of you, years in front of you is the beginning of the line. And once you get to the beginning of the line, then your visa number is current, and then you basically get your ticket and you can go on to the next process. So let me tell you what the preferences are. There's preference, and I'll just tell you how to refer to them. There's preference 1, preference 2A, 2B, preference 3, and preference 4. Okay? Now, generally speaking, there's some exceptions to this, but generally speaking, the higher the number, the lower the preference. Okay? Basically, U.S. immigration law has established a maximum number of people that can come in under each particular preference per year. And when the number of applications exceeds that number, that preference, then it gets backlogged, and that's what creates the visa waiting for it to become current. So the first preference would be a U.S. citizen petitioning a son or daughter that is over 21 and is single. Okay, that's the first preference. Now, let me just skip the second preference, which has 2 categories, but let me go to the third preference. Third preference is U.S. citizen petitioning a married son or daughter. And then fourth preference is U.S. citizen petitioning a sibling. Now, keep in mind that the petitioner, the U.S. citizen, must always be over 21. So even when I was talking about the immediate relative petition, I've had in the past some people say, well, I just had a baby born in the U.S. Now, where's my green card? It doesn't work like that. The baby needs to be 21 years old before that baby can petition you for an immediate relative petition. And likewise, let's say fourth preference petition for a sibling, the petitioner must be over 21 and a U.S. citizen. Now, so those are the U.S. citizen preference. So again, first preference, U.S. citizen petitioning son or daughter who's single, who's over 21. Third preference, U.S. citizen petitioning married son or daughter. And fourth preference, U.S. citizen petitioning a sibling. So what's the second preference? Well, second preference, 2A and 2B, are preferences for lawful permanent resident petitioners. So 2A is a lawful permanent resident petitioning his or her spouse and or child who's under 21 and single. And then the preference 2B is a lawful permanent resident petitioning a son or daughter over 21. So just a little tidbit here. A lot of times, a lawful permanent resident will petition a son or daughter over 21, and then they'll wait years and years, and let's say the son gets married. Okay, the son gets married, and then they still wait years and years. They finally get to the interview, and the officer says this petition's no good. It's void. Well, there is no preference for a lawful permanent resident petitioning a married son or daughter. So the moment you get married, if you're being petitioned by a lawful permanent resident, that petition is void. It's like it never existed. Okay? Now, so you can get an idea of the waiting times. They're anywhere between 5 to 25 years. Now, let me give you the outset, the longest. If you're from the Philippines and you're doing a sibling petition and you file it today and it's approved 2 days from now, the visa number will not become current for about 23 years. Okay? And that means, 2028, something like that. It's an incredibly long time to wait, and there are people who wait. Now, uh, depending what country you're from, depends on the backlog. So, the high impact countries generally will be China, India, Philippines, Mexico, those countries. And then when you look at the visa chart, it has a column for all other countries, and that's where it flies. So basically, the way it works is you find out if you're an immediate relative or what type of preference petition you're under, get the I-130 filed, get the priority date established, and then keep an eye on the priority date. And once it becomes current, you can either consulate process or you can come through an adjustment, depending if you're here legally or fall under one of the exceptions. And that is the basics of family law immigration. Okay, more on the coming videos.